Good evening. This is attorney Sam Shihab, and with me,
I'm Brian Burke.
and we are attorneys from the law firm of Sam Shihab and Associates. Today is Monday at 6 o'clock Eastern Time. This is the time when we get together and spend an hour to talk about current events, up-to-date information, take your questions, and answer them when we return. So today we're going to talk about 5 current trends in adjustment of status review by USCIS. Obviously, those who have their adjustment of status pending with USCIS for 6 months, a year, 2 years, 5 years or more understand and are closely following, especially if the priority date is current, following what is USCIS is doing, and if my case will be approved this year, am I going to get my green card? So this session is about talking about 5 new trends that we are seeing recently USCIS is doing in moving cases forward, and we want to share those with you. Our office processes a large number of adjustment of status and employment-based cases, so we obviously can see trends and we're sharing it. Yeah. But before we jump into the trend, there's a new legislation that passed, that was introduced. 1 out of 100, I don't know what the ratio is, 1 out of 200 becomes law. But this was specific for immigration. And Brian, let's talk about this new positive.
I'm going to challenge the idea of new, but it's out there again. You know, laws have it every time Congress is in session. You know. Ones that don't make it often will get reintroduced, and this one's called the EAGLE Act, and I understand it was previously noted as the FAIR Act. But
and it's introduced by a Republican and by a
Democrat. It's Hickenlooper of Colorado and Kevin Kramer of North Dakota, I believe, where he's from. And you know, these are the ones that kind of get us excited. You know, bipartisan immigration bills. Bipartisan meaning, you know, Democrats and Republicans coming together. And you know, when we look at these things, you know, these guys, in terms of their policies on immigration, their positions on immigration, these guys seem very far apart. And
they are. If you look at their background, one of them is a scientist and a geologist and a businessman, who is really on the left and has done a lot for immigration throughout his professional or
I mean, he was
career.
on the DACA, you know, push for DACA, save DACA. Whereas, you know, the other gentleman, Kramer of North Dakota, is a gentleman, you know, who was on the Trump train, his Muslim ban. What else did we see out there? Well,
conservative. He's a conservative guy. And it's surprising that he is on this ticket, but that's good news for me. I don't care. Get me a few other conservatives on board, get the Democrats on board, let's pass this thing because it has some good stuff. So what's in it, Brian?
Yeah, so it gets rid of the per-country limitation on employment-based immigrants, for one thing. And that's huge because, you know, that's what stops people from India and China from getting green cards immediately, puts them in a backlog, right?
Right. With the time limitation, of course, we're not going to spend a whole lot of time on it. But as you and I have discussed earlier, it does not have a net positive.
It doesn't make more visas available.
Yes, and it doesn't have a net positive for the real backlog. What it does is it sucks everybody else, all other countries in the same backlog. The backlog becomes one big backlog, and people from other countries don't get an advantage.
It makes it, exactly. You know, folks from India and China, the present system has a per country of birth limitation on it. And you know, the same visa case for somebody from India versus somebody from, I don't know, United Kingdom. You know, that person from the United Kingdom, you know, gets their EB2 green card in, you know, maybe about 2.5 years right now. Or less. And whereas somebody from India, you know, they're looking at a decade or so wait. So it's a huge disparity. And essentially, by getting rid of that per country limitation, puts everybody in the same bucket and eliminates that. There is a 9-year phase-in, which to prevent, you know, those folks from those countries that don't have the backlog right now from being, you know, offended and being surprised by suddenly having visas not available.
So people who file adjustment status right now don't really get to benefit from it. However, people coming through the pipeline who filed I-140s may benefit from this new provision. I'm not really excited about this, getting rid of the per country limitation stuff, because it really doesn't help the bottom line of green cards moving forward. But it's this adjustment of status could be filed within 2 years
After your I-140 is
I-140 is approved is huge.
Yeah.
Because it potentially gets you off of H-1B, and it's huge for the employer, because right now we have a limitation on H-1Bs. So,
yeah. Now that's a good point. Now the other side of this,
but that doesn't increase the H-1B cap.
It doesn't increase the H-1B cap, and H-1B is something we have to mention, because the sort of deal on this thing is apparently exists in the kind of new restrictions, new policies on the H-1B program. There's basically some changes regarding what kind of employers can sponsor H-1B employers, reporting requirements and penalty requirements for violations. So it sounds like the great, bargain here is that, you get to make the immigration backlog fairer in exchange for some tightening up of the H-1B program.
Yeah, but the upside is the I-485 filed within 2 years. For me, that's huge.
Yeah, that gives stability to people's lives.
Because you can jump from company, you can be self-employed, you can look around for work. I mean, it's huge.
Yeah.
All right, so that is called the EAGLE Act, was introduced about less than a week ago. And to our topic, 5 trends in adjustment of status filing. And let's jump in on trend number 1.
Trend number 1, so transfer notices from USCIS. So we are seeing a flurry of these. Every day I'm getting a good chunk more on my desk, and we'll talk about where they're coming from and what they mean. So one source of transfer notices is the backlog of the Nebraska and Texas Service Center. Everybody knows that Nebraska and Texas were not moving, right? And in January of this year, January, February, they started moving cases out of that Nebraska and Texas Service Center to the National Benefits Center, and in turn, in fact, the local field offices. So that's one source of transfer notices. And we are still seeing those. People who have had cases sitting with Nebraska and Texas, that's one source of people with current priority dates, cases ready to be adjudicated, seeing those moved out in Nebraska and Texas.
And would you call that a trend that we think that practically in Texas and Nebraska are really stopped processing applications?
Well, USCIS has updated its finally their statistics, and that's something maybe we'll take a look at next week. Whether what the current caseload is at some of the service centers. As I recall, yes, it has gone at Texas and Nebraska. 1, by getting cases approved, and 2, by sending them out to the.
And they have indicated that there is some old cases that are complicated and that are working on that are not normal cases, and that takes a long time for them. So they're not moving, but they're pushing most of those cases to the local field office through the National Benefits Center. So that's a trend. Yeah. So the second trend here, trend 1B. Yeah. Right. Still in trend number 1.
It's the other source of transfer notices. Yeah. It's so people who have needed to interfile in order to get to EB2, those folks are generating transfer notices as well. When you're interfiling, we're seeing basically transfer notices come in within about a month.
So within 1 month of filing the interfiling request.
Yeah, we're generally seeing, a transfer notice saying, we're picking this case out of our backlog off the shelf somewhere, likely Texas and Nebraska, sending it to somewhere where somebody can adjudicate the case.
So the file is moving within 1 month of the request.
Yeah. To me, that says, we know your priority date's current now because you interfiled. We're sending it to somebody who can actually approve your case.
And then the trend 1C is we're seeing that when that happened, that we're seeing action within about 4 weeks?
Yeah, about a month. We're seeing those cases move, and we're seeing positive things happening.
Yeah. And I'm going to add, I know we have our 1A, 1B, 1C. I'm going to add one more.
Okay.
1D, trend. Tons of approvals.
Yeah, that's good.
Tons of approvals.
I was going to bring. I was going to call it 1D, but USCIS. I think it was on the.
They're coming.
On the
approvals are coming.
Yeah, on the 18th, I believe it was. They updated their FAQ, and I talked about this last week, to say that they've approved 176,000, I think it is, employment-based green cards this year. and that leaves them with 100,000 to go. And they say they are well positioned, to approve those, and they are starting to make me a believer because I have. Well, there you go. I'm seeing it in what's coming through across my desk.
Trend number 2. Calls from USCIS. What are we? We're getting calls, huh? They're calling us.
These are strange. Now, USCIS, for those who aren't aware, USCIS doesn't call us very much.
Infrequently.
Yeah, we're immigration attorneys who do stuff with USCIS all the time, but they typically communicate with RFEs and receipt notices and approval notices.
Yes.
And I will get a call, and Allison, our nice assistant, will say, Brian, there's somebody from USCIS calling, and on the other end, you can just hear what they're doing. They're sitting at their desk with somebody's green card case in front of them, and then they start, asking us questions about what's going on.
Because they want to approve the case.
Yeah, they're basically saying, the things we've heard is, hey, I see 2 green card applications here in front of me. So somebody who has filed an EB2 case and EB3 case. Can you guys tell me what's going on here? And
help me out.
Yeah, and it's going to be, both of them, one of them has a current priority date, go ahead and approve it. Or, hey, I see this person has 2 I-140s here. Can you tell me what's going on?
Explain that to me. Because some of those guys are family-based oriented guys at the local offices, and they might need the help from an attorney that says, explain to me, what's this adjustment? I got 2 I-140s. I'm just walk me through this case so I can move it. And what are we seeing after these calls?
So literally, an early one I had, approval is a short answer. Sam,
yeah.
It's they said I'll tell somebody, hey, I'll talk to the applicant, and I'll let you know in 10 minutes. I'll get that officer's number, and I'll call back and say, I figured out. I think I'm good. I approved the case. In between the last 2 times we talked. So very quick approvals at that point. And I've heard people. Applicants getting calls as well, not just attorneys, and they'll call me up and say, is this legitimate? And I'm saying, yes, this is something we're seeing, right?
It's scary, right? When with all the fraud that's going on, people say, well, who am I going to talk to this guy? Give him some information.
Yeah,
so
and you really don't
it's
have.
It's good news, but it's scary too at the same time.
Yeah, because you don't want to. People are afraid of saying the wrong thing to them, of course, as well.
Yes. So if you receive a call from USCIS.
Yeah. Yeah, you got to give a disclaimer.
You might want to just say, I want to answer, I want to help you. Give me a piece of information like, what's my social security number? If you think, what's my address, right? What's my mother's place of birth? No, they don't have that on that adjustment, do they?
They won't have your mother's place of birth
on that adjustment, right?
On
whatever.
the I-45, yeah.
Can you look up my mother's place of birth on that form and tell me what it is, so I am trusting you as USCIS to be able to answer your question. I'm sorry, because there's so much going on, and I want to help you. So,
yeah, I've heard horror stories about about fake government folks.
Yeah, so you can just say, I'm sorry, I'm being cautious here, I want to help, but if you can help me, make me comfortable that you are in fact USCIS, we're here. I mean, obviously we're attorneys, we're used to it, we can figure it out, we can smell it.
Again, I can, it's funny, Sam, I can hear a USCIS officer's office on the phone, and I know exactly what it looks like in there. I didn't know what their files look like, I could hear them rustling the big stacks.
They're nice people. The individuals are nice people. They want to move cases. I tell you,
they're all extraordinarily friendly. The ones I've dealt with, and they're just left scratching their heads over something. And happy to help you with that for sure.
Yes. So that was trend number 2. Let's move to trend number 3.
So RFEs. So there's really 2 types of RFEs that we're seeing right now. Medical RFEs and interfiling requesting RFEs. So we'll touch on the medical ones briefly because those are the far less interesting ones. So USCIS, for anybody who's not aware, their present policy, their FAQ online says, hey, don't send us unsolicited medical exams right now. They're causing us a headache. When we get them, we have to hunt down, your file, and we stand a chance of losing them if we get them right now. It
slows them down.
Yeah. So they say, hey, basically, if you think your medical exam's expiring soon, get yourself an updated medical exam and have it ready for us.
Don't send it.
Yeah.
Right?
Yeah, ultimately for people who filed in October 2020, their medical exams are going to be expiring soon because they last 2 years at this point.
So but prepare them, because what they want you to turn that medical RFE back within 24 hours to them.
Yeah.
You get it, it's ready, you mail it, send it back, the file is still fresh in the officer's hands, he or she receive it and approve the case. So that's what they want you to do.
Yeah, that's exactly. Yeah.
And that's trend number 3 with the medical RFEs.
Yeah.
Now with the interfiling RFEs.
So yes, so interfiling must be a request made in writing per the USCIS policy handbook, and they want them because they are, again, I have to applaud them. They seem to be making an effort to get these cases approved, and they're looking at cases saying, "Hey, we think you have another I-140 available in another category. Hey, could you send us requests that we change basis so we can actually do that?" So there you go.
That's fantastic.
yeah.
And you know, you should do it. Talk to your lawyer so they review the file so there's no issues. Now, there is that little catch.
Yes.
The child status.
The little catch is about 4 feet tall, but I guess the Child Status Act is an issue. It's going to be 5.5 feet tall, perhaps.
Yes. So the Child Status Protection Act issue, switching bases may have an impact on the Child Status Protection Act. The officer may be in the rush. They don't study these things carefully. So consult with an attorney if you have an aging out child. Make sure that your interfiling will not negatively impact.
Yeah, USCIS in their employment-based adjustment FAQs recently confirmed that if you look to, the CSPA is controlled by your underlying I-140, so that's something you really have to worry about.
Yeah. So if you don't have children that are aging out, you don't have an issue. But if you do, just be aware of that.
Yeah.
And that was trend number 3. Going to trend number 4.
Inquiries.
Inquiries, yes. So what are we seeing, Brian, with Congress or Ombudsman inquiries at the present time?
I'm going to include USCIS inquiries. So 3 topics, A, B, C, and D. My short answer is going to be nothing, nothing, nothing. So USCIS service inquiries, they're largely non-responsive lip service answers. That's if you can make them. People who have cases stuck in Texas or Nebraska, I was talking to somebody who has a case file in October 2020. They said, we don't want to hear a service time for out of processing until, I believe it was March of 2023, then well into the next fiscal year. So service inquiries, they will only take a service inquiry if your case is out of normal processing time, and odds are the way the processing times are so awful right now that, they either won't take one, or people who have put them in, Sam, they're getting lip service responses and they aren't hearing it back on them.
They're not getting any results.
Yeah.
Same thing with the congressman inquiries, right?
Yeah. So in my experience, congressmen will basically, tell you, oh, your case is processing, or worse still, they'll say, no, your case. They'll take the USCIS company line and say, your case is within normal processing times, meaning we can't do diddly-do about it.
But the ombudsman has just turned in a report to Congress on June 30th, and the key discussion in that report is the concern about delays in adjustment of status. And there appears to be congressional interest in that topic because of the number of people who are complaining about delays. So that obviously is turning everybody's attention on this, and USCIS is aware of that, and they believe that if they can approve all those cases this year, they can probably look like heroes in front of Congress. And that's something that they are trying to do.
At the highest level in USCIS, Sam, no doubt at the political levels in USCIS, there is much pressure there, so they don't look terrible.
So trend number 4, inquiries are not yielding meaningful result because USCIS is rushing as fast as they can to approve cases, and they are not going to pause, stop, and look back or answer or do anything customized.
Yeah, and it's just frustrating for the select few who still aren't having their cases picked up by USCIS.
It is very frustrating. All right, sounds good. So trend number 5 that we're seeing in the adjustment of status cases is what's going on with interviews, Brian.
So down a little bit. They are in a place right now where they're trying to prove as many cases as possible. And this time last year, Sam, I was, and you were as well, bouncing back and forth across these United States, attending interviews with people. I had a week where I was on the Eastern time zone, and I was in Florida and California. In a single week. And those interview notices...
And Columbus.
Yeah, and Columbus, of course, back in the office. So those interview notices are still coming in, and bottom line for me is I'm seeing, what I think are more straight approvals and less interviews. The ratios are a little bit different.
So what are the trend 5A, 5B, 5C on interviews? Where are we seeing interviews?
The classic, criminal stuff. If you have something, beyond a, traffic tickets,
they want to talk to you.
They're going to want to talk to you, and they generally speaking, review the forms thoughtfully, and lots of people have to check. Yes, I have, a moving violation in my car. And those people generally don't get called in, but it's, that's a classic one. That's one of those things that's taken me to a lot of interviews.
And the second one?
Unusual employment history. So the number one for me is, if you are filing an adjustment through a company that you aren't employed at the time you're filing adjustment, or if there's some sort of interruption in the continuity of your employment history with your sponsoring employer. So the classic scenario is, for people who are like from India, for example, who are in a 10-year backlog, I know a bunch of people, who in like 2018 or 2019 said, I'm never getting this green card. I may as well, I'm gonna find a new green card sponsor, new employer. And when their priority date came up suddenly, magically, unexpectedly in October 2020, they said, well, going back to my prior employer, gonna rejoin them. And those generated a fair amount of interviews.
Yes. And obviously, anybody with questionable status history, we're seeing some of that.
I've a surprising amount of lookbacks, to student status. I've seen with skeletons in closets.
Tri-Valley University.
Yeah. Any Erguvan University, University of Northern Virginia. People who got involved in those sort of places.
It's not a deal killer. You just have to explain what happened, and hopefully by now you have resolved those issues in a favorable way. But they've been looking at it. It's basically a status review, and that's a flag. I mean, it makes sense.
They're looking at people were taken in by these, more or less, frauds, and basically they're looking to see if, you had any sort of knowledge or knowing that, there was a problem there. And of course, there's always the random interview. People sometimes just get called in for interview. Quality assurance, I guess you would call it.
Absolutely. And that is our 5 trends that we're seeing in adjustment of status filing. And when we come back, we're going to take your questions or any comments on today's presentation. All right, this is the time in our presentation that we are going to take your questions. Feel free to comment or ask questions about our current presentation or what we've presented today, or anything else that is not related. But
I'll take questions regarding back topics as well as future topics.
As long as it's immigration law.
Yeah.
And we will do our best to answer it. And we have the first question.
Here we are.
From Dr. J. Goraya. The processing time for EB-5 keeps going up from 37 to 42 and from 46 to 52 months every month. Can anything be done for that? What court of law would you say it's okay to keep putting those cases off by USCIS?
So one of the things I think about this EB-5 issue is, they had half the EB-5 program suspended for a while, as that was sort of re-adjudicated, and they basically stopped processing cases. So that certainly would have contributed to a backlog. But USCIS definitely has a problem problem with that. The fact that they just can't get any. 3742. That's also the EB. I'm assuming that's referring to the EB2 case itself, EB5 case itself. The change in the EB5, the allowing to file adjustment of status early though, Sam.
Something though. I think there is an issue with pulling resources. So right now, I think this year is all about adjustment and backlog and Now, if there's anything I can tell you is they're probably pulling every resource they have on this
Yeah,
issue.
so we talk here, Sam, about employment-based green cards a lot. And one of the topic last week was, well, how the non-usage of family preference visas, the lesser usage of that, will roll over into the employment-based categories. What's that doing to the poor folks who are in the 15, to 20-year family preference backlogs? I appreciate, that the employment-based folks are very happy that they're going to use all these green cards, but others are getting left in the lurch, and I guess it's a fundamental problem in our immigration system.
Yeah. Well, there's a lot of problem with it, especially EB-5. As a matter of fact, there was an article that I've read yesterday about how the millionaires in the world are not coming to the U.S. anymore. They are going to Dubai. They are going to Singapore, and they are going to Spain, Europe, and they are not coming to the U.S. and they're not coming to the U.K., which used to be the two countries that everybody wanted to go to.
Well, I mean, we talked to a lot of people about doing EB-5s, and some people say they read on the internet about EB-5. I'm bringing $1 million to the United States. That's the visa for me, clearly. And sometimes we tell them, hey, there's some fundamental problems with the EB-5 program, and you're running a business, you're starting one abroad, you're starting one in the United States. Those folks end up as EB-1C managers and executives and get a green card much faster than they ever would on the EB-5 track.
Yeah, 100%. And also, it does help people, for example, who are E2 country, treaty country, because you can convert an E2 to an EB-5,
Yeah.
so you can get them in on E2. And then
that helps people who are here already, and also the ability to file adjustments for the EB-5s is something they've tried to mitigate this. But for somebody who's outside the United States waiting for that EB-5, good luck.
Yes, absolutely. Yeah, we do talk about L visas and intercompany transferees. So much easier to deal with than an EB-5. Yeah. All right. So from Yogesh, Brian, take that one.
So how positive are you that April 13th, 2015 EB-2 will be current for dates for filing either in October, November, December 2022? Also, when do you expect April 13th, 2015, I presume, to become current in final action dates? So,
I like the question of how positive are you?
Yeah. I'm a positive person in general, of course. So you have a copy of the visa bulletin there, don't you, Sam?
I do.
So I know the furthest visa bulletin. The furthest visa bulletin is made in the EB-2 category. Final action dates there, December 2014. January, February, March, April. You're a little bit more than 4 months away from being current, Yogesh. And in terms of in October 2022. That's when the new yearly allocation of green cards become available, and we're also going to see, whatever additional rollover we get, from the prior fiscal year, the fiscal year we're in right now. I give that a pretty good good chance of seeing that kind of movement, right?
So you're reasonably positive.
I'm reasonably positive. That's
Awesome.
The short answer.
Yes, and Meta has a question for you.
Oh, okay. Oh, I'm Brian from Sneha Mehta. Hi, Brian. A green card holder can't stay outside the USA for more than 6 months in the year without a reentry permit. Are they saying same calendar year or any continuous 12-month period? Any continuous 12-month month period, and is the short answer to that question, and that's that. And again,
Well, first of all,
that's a simple answer.
Well, go ahead.
Oh, yeah, well, okay. Well, and I'm always happy to reject the idea that just leaving from 6 months and coming back is enough to keep your permanent residence. It's about permanent residence. It's about where your heart and your mind are at, whether you are permanently residing in the United States. And
Right.
if ever you come to the border and the customs folks believe you aren't really residing in the United States, despite how often you travel, you could be questioned as to your green card status.
You can leave and come back. Let's assume you leave. And let's assume your family own a property back home and you are in litigation. And it necessitates you being there for 8 months. And you settle the litigation and then you come back. Nobody can take your green card from you or question your intention. And when you left your home.
Oh, sure. It's fact sensitive.
Your wife was in the U.S., your children were in the U.S., nobody will question that. So that 6 months is everybody get confused about this number. It is not a number you should rely on. It's the totality of the circumstances. Now, on the other hand, the longer you stay outside the United States, the more questioned you will be. And once you cross that 6 months, there is that presumption that they have that they would like to question you and understand why you've been outside the United States for more than 6 months.
Yeah.
This topic deserves a deeper understanding from you as a green card holder. You might want to do a consultation with our office or with an attorney to have a better understanding, because there's more to it than we just shared.
Yeah, it's more complex than you might think.
Praveen, January 21st, 2015, EB2. What?
So thoughts
on filing and final action dates.
So final filing dates right now are at January 1st, 2015. I think there's a reasonable chance in September Visa Bulletin, Sam, that we will see dates, the final action dates get back to January 2015, which will leave Praveen here, coming into the new fiscal year.
Ready to go?
Yeah, 3 weeks off of current. I'm not a gambling man, but
I'll put my money on that one.
Yeah.
Yep. All right. So I will not try to pronounce your acronym. I will not try to pronounce it. What do you think?
Ivyk.
All right.
I'll take a guess, and I apologize if I butchered it.
AYKYK.
AYKYK? IYKYK.
IYKYK.
Well, let's address
EB2 NIW.
Yeah.
All right.
Concurrently filed in July of 2021 with I-693 included. FP done, fingerprints done in November 2021. I-140 approved in late May 2022. Yeah. I-45 transferred to NBC last week. When do you think I'll get that green card? Anytime?
Trend number 1.
Yeah.
The trend number 1 transferred to NBC recently. You should hear a decision or an RFE or a call within the next few weeks.
Yeah. I mean, you are not. I mean, yeah, you're in the EB2 category. They are trying to get EB2. They have green card availability this year, and they're trying to use them up before the end of the year. You're special. You're a little bit special. You're the EB2 national interest waiver. Congratulations on getting that approved.
I'm not saying the priority date. Well, obviously, it transferred to the National Visa Center, so priority date is current.
Yeah, I'm presuming your priority date is current. Yeah.
Yes.
So.
All right, Mr. Castro. My L1B expired on August 31st. Green card pending since September 2021. Was transferred to NBC last week. Same question. Wow, everybody's getting their cases transferred to NBC. That's very consistent.
I would say it's one of the 5 current trends in green card processing, Sam.
Yes, that's a good trend list, Brian. What are the chances that I get the green card before the L1B expires? August or July? I think you're very good.
I think they're very good. So one thing, this is something I saw towards the end of last year a lot, but, I think your problem is, Mr. Castro, sir, is that, or madam, I'm not sure, that you don't have that green card EAD yet. That would really kind of alleviate the problem of having not having the green card yet, because it sounds like you're probably worried about lapses in work authorization. And in the past, even though it's not really on their list of priorities for expedited processing of EADs, I have seen people be successful in, saying, my work authorization is lapsing because you guys are slow on my green card and my status is expiring. They may be willing to expedite the processing of that.
But I'm assuming that action will be taken to extend that.
I am hopeful. I mean, I've seen people filed at similar times and either getting, green card approvals or interview notices.
Yes.
Yeah.
All right.
I'm hopeful.
Yep. Okay, so Mehta, I have a green card. I took a vacation to India for 4 months in 2022, returned to the United States in May 2022. Can I go back to India for vacation, personal purposes, not employing purposes, another 4 to 5 months in 2022? Well, the short answer, the answer, yes, you can. Now, having said that, we have to clarify, right?
I mean, it's the totality of the circumstances.
Number 1, love your lifestyle.
Yeah.
You take 8 months vacation a year.
Sam, can I take 8 months vacation and come in the next year?
I'd love to be able to do that. And I just came back from a long vacation. Or I thought I took a long vacation, which is 3 weeks. And I haven't had one in my entire professional career. a 3-week vacation, and I'm tired. I'm looking forward to come back to work. How can you take 8 months vacation? But I'm impressed. Let's answer the question. It all depends on, again,
it's
totality of the circumstances.
If everything in your life, points to, still residing as a permanent resident in the United States, that's possible,
But I will have to add, with all due respect, if you're questioned by an officer, say, what were you doing in India for 4 months? You say, well, I was on vacation. And then they're going to ask you, what were you doing for another 4 months? You're going to say, I'm on vacation.
Yeah.
They are going to be
Those
confused.
guys are human beings with their own personal biases, and they say, well, I get 4 weeks of vacation a year, and you get 8 months of vacation a year. It doesn't sound right.
Yeah, well, that's a great that's a great lifestyle. So you just have to explain, I think you have to explain a little bit better than just vacation.
Yeah.
But, hey, I'm reconnecting, I'm enjoying myself, I'm taking, I'm back home, settling property. As long as you're keeping money here in the U.S., your house, if you own a house, if you're single, fine. But if you're married, obviously, spouse.
Well, Sam, do you know who can leave the United States for long swaths of time and always be guaranteed to come back?
U.S. citizen.
U.S. citizens. I don't know how long you've had a green card for, Sneha, but that's kind of.
Well, and but that is going to also impact your ability to get.
That's true. That's an analysis. That's an important
But
part
the
of
answer to the question, yes, everything is equal as long as your ties to the United States are well established and well documented. You should be able to do that. All right. So Yogesh, how positive are you? Is this the same question? Did I miss it?
No, I think
it begins with how positive. I'm kind of taking it back.
We got that one. Yeah.
All right. Okay. Sounds good. So we go next one here.
So, from SIVA, online case data says request for initial evidence was sent for I-45 refiled in April 22 for EB2 both. What could be missing? Included medicals, birth certificate, affidavits with application. So, great question. Requests for initial evidence, those usually mean something they think is fundamental to the case. USCIS sometimes loses stuff. I've definitely seen cases where they lose, say, photos, for example, and they issue a request for initial evidence on that.
Sometimes simple stuff. If everything is complete, just be patient and respond to them. It can be a simple thing. And that tells me that they're ready to approve your case, and it sounds like a simple request. Give it to them, let them approve your case.
I have also seen that birth certificates with affidavits, the question is, it says birth certificate affidavits. You may not have met the requirements to actually hand those in yet. For example, if you just hand in affidavits and the government says, basically, it might be U.S. government policy that based upon where you were born, that we won't accept affidavits without evidence from the birth certificate office in your home country.
That's all speculation. It's minor stuff. Be ready to jump on it. Give it to them. They're ready to approve your case because they're looking at your case.
I could find 1,001. You're right. 1,001 reasons why.
Yes. All right. So next question. EB from Banim 100.
Yes.
EB3 I-45 straight filed in 2020 October. I-45 interview was in December 2021. Wow, that's okay. No status update after the interview. Interfiled to EB2 on June 1st, 2022. Priority date June 2014.
So, I know I can think of some people I know who have that exact same scenario. And when can I expect my green card, Sam?
Anytime. But has there any been? Obviously, when you were interviewed, it's a local office. So we've had people with similar situation, and sometimes it all depends on the interview.
Yeah.
Because if, for example, there is a question about the authenticity of a document, then they have to contact the consulate, who will contact the school to get back and get them what they need. I'm not saying that's the case in your situation. All I'm saying is I don't know what happened in the interview. I don't know anything about the case to comment, but you've had an interview, and I would be curious to see what happened in the interview.
How did your interview go?
Yeah. So
bottom line for me, they are trying to process as many green cards as they can before the end of the fiscal year ending on September 30th. So that's the optimistic version, but that's not a guarantee for everybody. If they have an issue they're concerned about, they could in theory say, "I'll see you next fiscal year."
Yeah. All right. So Siva, what's the difference between an
RFIE and RFE?
Yeah.
So RFIEs are requests for initial evidence, and those are typically issued on pink paper. And basically, it means they think something's missing from the case. And what we already answered the other question. What could it be? Something they think is important, but who knows?
And RFE is request for evidence.
Yeah, request for evidence is anything else, and we need more than what you gave.
Yes. All right. Okay, Regini Gupta. Are the Child Status Protection Act rules same regardless of underlying visa? H-1B primary H-4 kid, L-1A, L-B primary L-2 kid, subsequent green card category EB-1, EB-2, any exception differences? For the most part, they are the same, but it start to get difference is when the green card apparatus, for example, consular processing versus adjustment of status. These can differ, interfiling and multiple I-140s, then you'll take different paths.
Yeah, I think if you think you have a serious, CSPA quandary, that's something where I'd say I don't think we could ever truly get into that in the necessary detail during one of these sessions.
Correct, but just the general, H-1B, H-4 versus L-1, L-2, the same. They're not treated differently, but the path you take for the green card process can lead to different results. Would that be a good way to say it, Brian?
Yeah.
All right. So Raju, take Raju, Kaladindi.
So I-45 Supplement J receipt notice has incorrect employer's site. Instead of Arlington, Virginia, it's mentioned as Newington, Virginia. Do I need to raise a service request? So my answer is sure, it doesn't hurt. Is it likely to change anything? No. But I don't think it hurts to put in a service request.
Yeah, it's an immaterial.
Yeah,
and I would want to know what happened, why that happened in the supplement J. Because that helps me explain it. New supplement J also, they may ask for a new supplement J. Be prepared to put one together.
Yeah, I would want to see what the supplement J says, of course.
All right. So Irshad Sheikh. Minor mistake in 693 civil servant date of signature. Is it a problem? Well, it all depends on what is the minor mistake. If he put 2020 instead of 2022, that's not a minor mistake.
Yeah, I mean,
one day off, that's not a big deal.
It's like the date a civil servant signs something it also affects like the validity length of the medical exams, But if you put a future date, I think that might cause USCIS to issue a very stern RFE saying, what's the deal
What's going on with this, yes. My advice to you is to go back to the doctor, issue a new one, and be ready. Yeah. If they haven't raised the question, it's minor and immaterial, they've concluded that, and you're fine. If they haven't, then you might want to be ready with a correction.
Yeah.
All right.
From Arun Prasthant. Submitted an RFE on June 15th, still waiting for an update. I changed job and moved to a company on June 20th before 180 days of interfile. August 6th will complete 180 days. Will I get green card by September? So I do have a concern. So I'm hearing that somebody has changed employers before hitting 180 days since.
But there was no RFE or no issue raised by USCIS.
Yeah.
So once you cross August date, whatever that's say,
get that supplement J in.
You'll be fine. Yeah, exactly. Yeah. And then keep your fingers crossed.
Yeah, pretty good chance for September, I'd say.
Yeah, I don't have a problem with that.
Yeah.
All right, Irshad Sheikh, can we send medicals with 45J? Transfer underlying basis RFE.
That's an interesting, take on it. But I'm gonna, abide by. Well, first of all, they would send you a medicals RFE if they want it medicals. And anybody, Irshad Sheikh and probably so many others, they would have filed adjustments in October of 2020, right? Meaning their medicals are still probably valid through.
But if they have an RFE, somebody has the file open.
This is true.
They don't have to hunt the file.
It's. I wouldn't want to go against the wishes of USCIS by telling everybody to send, unsolicited medical exams. But you're right. It's a relatively low risk scenario.
Yeah, I might do that. Yes, I would do that. That's Brian, a little bit more conservative sounds like. But if you want to send medicals, somebody has the file open.
Yeah. Yes, I would agree with that.
Hey, Sam and Brian, take that one.
Yeah, from Kevin on Facebook. So, hi, Sam and Brian. Thank you for an informative session and appreciate your outreach to the immigrant community. Here's my case question. EB2 national interest waiver was concurrently filed in June 2021 with I-693 included. Fingerprinting was done in November 2021. I think we may have taken this question on another platform, Sam. And EAD AP was approved January 20. Oops.
Sorry about that.
No, you're fine. EAD was approved. And this is from Kevin Reeve. You go down two questions down, Sam. I think there we go. Was approved. Also, please ignore my comment on YouTube, which is duplicate. Your YouTube comment got here first.
And we answered it. But thanks, Kevin. And if you have any more questions, let us know.
Yeah.
All right. So we go to Praveen.
January 21, 2015. EB. We already got that one, Sam. We're getting some duplicates here.
Yeah.
That's okay. Easy to get through when they're duplicates.
Yes.
My date is current for 9 months. My I-140 is with my old employer, so doing transfer with them. So I presume doing a transfer with them, maybe that means H-1B transfer.
Yeah, I don't see any follow-up from Vera.
Yeah, I don't see one either. So it's, well, if we find it, Vera, we will.
Yeah, we're not clear, Vera, so if you can rewrite it and drop it in, we'll try to catch it. All right, from Sai, what are the chances of getting priority date August 2016 EB2 current in the next fiscal year?
That's a year.
We're going to do, we've done a session about predicting the overflow and the visa bulletin for next year.
Yeah.
We will do an updated one in the next couple of weeks.
Yeah.
Because there's new numbers, updated numbers from USCIS. And we crunch the numbers. So in terms of answering that question, keep track of our presentations, and we may get into a very deep dive into this topic in the next couple of years. But it is a little bit further than we think. Would that be a preliminary?
I mean, that's a little bit more than a year and a half, and our top projection was, about a year and a half. So
yes,
I'm optimistic, and I cross my fingers for you. It's just might be a bit too much for the visa bulletin to handle.
True. Yeah. RV, got my green card in EB2 as an accountant. Yay! How long should I be working as an accountant before making a switch to IT, higher salary field? Just want to make sure there are no issues during naturalization. All right. I would be very comfortable, but that's not the question. I'm changing the question. I would be very comfortable if he goes into IT, dealing with something that has an accounting underlying.
Sure. And I know that sort of role exists. It's working with dating-based systems.
But it could be that he is dual. Trained, and he is completely abandoning. After all, I used to be an engineer, and I don't do any engineering anymore. For 25, 26 years, I've been practicing law, and I've not done any engineering, so I understand it. But to answer the question, I think it's reasonable time is the law, and what is reasonable time? I would say, I don't know, Brian, that's a tough one.
So, I'm going to start with the one extreme, which I wouldn't say abide by. Once you have a green card, you are a permanent resident in the United States. You're eligible to live wherever you want, and you're eligible to work wherever you want.
And do whatever you want.
Exactly. However, when you took that green card, your employer, you agreed that you're going to take that role, and they're going to offer that role, and you're going to take that role. And I'd say it's a totality. I think it's back to the totality of the circumstances, Sam. If something's different, something's changed. For example, if you got fired as an accountant, I would say
I'm going to make it easy for you. I'm going to start by saying, would you be comfortable if he worked for 1 year as an accountant and moved on?
Sure.
Okay.
Yeah.
So now we have an upper limit. Would you be comfortable if he worked 3 months as an accountant and left?
I'd be feeling a little bit more squirrely.
Okay. So definitely not less than 3 months. Not 3 months. How about 8 months?
A little bit better.
8 months, more than 6 months.
Yeah, I mean, so
I think I personally, when number one, it could never come up. You can do naturalization, nobody will ask you a question. But when I personally become very uncomfortable when you cross 9 months, less than 9 months. I feel uncomfortable. You crossed beyond that, I personally feel like you're okay.
You know, when I think about this, I think about, is that enough time for circumstances to change? You know, when you took that green card, you know, you took that green card knowing you're going to take this job for an indefinite, you know, quote unquote permanent basis, you know, and
but that's my feeling. It's a feel. There's no law or rule on that.
Exactly. I mean,
hopefully that gives you a guideline.
Be a little bit conservative. It's your life. It's your whole life.
For sure, Brian is happy with 1 year. I'm happy with 1 year. Less than 9 months, I become squeamish. Brian, maybe.
But again, Sam, somebody could approach me with, Brian, I just got my green card 20 minutes ago, and the company just folded. You know, that's a scenario where you can change. It's all facts sensitive.
Exactly, precisely. All right, so JCP ready. January 6th, EB2 2015. Thoughts on final action date? Meeting this in September or October of 2022. Brian.
So in September, you know, I don't think so, because that's a couple days beyond where they've made the visa bulletin, where the furthest they've gotten the visa bulletin, and they would be soliciting new green card cases during fiscal year 2020. We are on 2022 right now.
But he gave you October 2022.
Oh yeah, October 2022. Yeah. Mark your calendar. Look for a visa bulletin. You know, that first couple. You know, early September.
We believe strongly that you should make it by October 22.
Yeah, I think there's a very good chance of that. I'll be flabbergasted if the visa bulletin doesn't move any for October.
Yes, Avinandan Nan. Perm was processed when I was in the U.S., but I-40 was processed when I was in India, as I had to go back due to H-1B renewal denial. Came back with H-1B again, working for the same employer. Do you see any issue?
No.
Good answer. I agree.
Yeah.
Raul Jain.
A two-parter.
1 of 2.
Yes.
I got to look for the second one. I don't see it. All right, let's go back. So I don't see your number 2 yet, but we'll look for it.
Okay.
All right, Brian, take it.
Hi, we filed AOS in September 2021 as part of EB3 downgrade, but with amendment as successor in interest. Interesting. It went to LIN. I-140 was approved in EB3 in February of 2022. Dates were retrogressed on October 1st, 2021.
I do not see part 2. I looked everywhere.
Some interesting facts there. I can't quite.
I am so sorry. I do not have part 2. Please drop it, and we'll be happy to go back and revisit.
Yeah.
All right. Okay. So, is it?
Sarvan Kumar Vanaparthi.
Yes.
So, hello. I have interfiled last month and got a receipt notice. My I-45 is still at the Texas Service Center. Should I interfile medicals? If so, which service center should I send to? Thank you. Well, the answer to that one is, per the request of USCIS, no.
Do not interfile medicals and have it ready for them to request it.
In the event of an RFE, yes.
Yeah. My date is current for 9 months.
Going to, I don't know what that is, but
all right.
So we'll come around to the second half of it. So
if we get it, we will. Let me see if I don't see it.
Yeah.
Okay. Did I see it? Did I see it? Yeah. Here we go. Sorry. Going to transfer H-1B. Will there be an issue?
So prior date's current for 9 months. Yeah. Transferring H-1B. So if you're changing H-1B employers, I mean, obviously there's a question as to whether or not your offer of employment is going with that H-1B. So you might have to consider filing a supplement J if you're really changing your permanent employer to that new employer is the first thing that comes to mind.
Yeah, I need to know a lot more. I mean, is the green card with the same employer? I mean.
Oh yeah, you're right. You could be transferring back to your green card. Yeah. Green card employer.
There's a lot more I do not know here to give a good answer.
Broad answer is they can approve an H-1B extension or change of employer for you with a pending.
There's no H-1B problem for you.
Yeah.
You'll be approved. Now the question is there a green card problem, and that I require to know a little bit more.
Yeah.
All right, so Suman, sorry we took you on the screen and then off the screen.
You're back.
But you're back here. My EB2 is current, and my spouse downgrade application moved to NBC without upgrading it. Okay. Why would that happen without finding out if supplement J or her date being current? My prior date is August 2014, EB2, her 2014, EB3.
So basically, I think it's, your spouse is moving, but my spouse is moving, her date's not current, but
mine is not moving and is current.
Yeah, so it could be, I don't know where your case is, I don't think it says, but they could be consolidating the cases to the same place, for one thing. And also, so it could be the sort of thing where you get one of those calls from USCIS saying, we're seeing a whole bunch of cases around here, because it sounds like,
I don't see a relationship between the wife and the husband cases that are
independent
of each other.
I imagine this, it sounds like that both of them, a green card case was filed probably by one is the spouse, each spouse is the primary person. I can imagine them trying to consolidate those to make their lives easier.
Okay. All right. I'll take that.
Yeah.
It's a total speculation on that.
Yeah, this is true. Nobody had only USCIS knows, and I expect only one person within USCIS knows whoever got that case on their desk.
So the rules in is 2 of 2.
Yeah.
So it's popped in here. I wish I can find her first one.
I think you're too far down. Yeah, up rather.
All right. Let me see here. Do you see it, Brian? I'm looking.
There it is, right there, that one. Raul Jane. So we filed AOS in September 21, part of the EB3 downgrade, both amendment as successor in interest. Went to LIN, I-140 approved in EB3 in February 22. Dates of retrogress in October 2021. I think you've gone down too far this time. Yep, keep on going up. Wait, I saw it down. I think I saw it. Yeah, I'll scroll maybe. Nope. I'm losing it, Sam. It says like 1 of 2, and oh, there it is. So now last month our I-45 moved from LIN to NBC to field office. How come? Since the dates are not current. So darn it, your priority. So sometimes they move cases before your priority date's current. I guess one thing I will mention, the government, in the best of times, they try to basically get cases ready to be approved before they are approvable. So it could be a situation, if your priority date's not current right now, if they foresee you becoming current in the next fiscal year, possibly, I don't know, I don't recall what your date was, but that's something they occasionally do.
Yep. Good.
It used to be in times when the priority date was moving in normal ways, that a month before your priority date was about to become current, you'd see an RFE, for example, asking for.
So Vera is clarifying my case. My case is I am going to do a previous employer green card continuation, but my date is current for 9 months. Will there be an issue while I'm doing the H-1B transfer on the grounds of my dates are current?
No, since you filed your adjustment of status, they should allow you to extend your H-1B.
Right. Is there a problem with the green card?
Again, it depends. So going back to a prior, it sounds like going back to the prior sponsoring employer. No, that's sort of a logical thing. That's something that I think about when going into an interview scenario. That's something that a USCIS officer wants to see.
Brian, do you know what IYKY stands for?
Well,
IYKYK stands for?
I know what IYKYK stands for because IKYK stands for if you know, you know.
All right. I like it. Good.
We did not know.
Give him one of those buttons.
Okay, I'm gonna. This one says Wawa next to it. I don't know what that means exactly, but is it going to turn off? That turned off.
All right, moving on. 658. All right. Boninum 100.
Yeah.
EB3 I-45 straight filed in October 2022. I think I answered that one. I-45 filed December 2021. Okay. My status update after the interview. Interfiled EB2. Yeah, we answered that one.
Yeah.
We can expect a green card. So we kind of answered that one.
Yeah,
right?
I think we skipped one here along the way, though. I think we skipped Rohit Devarma. Yeah.
Okay.
Here, yeah. So what is the priority date for December 24th, 2014 becoming current in September Visa Bulletin? So September Visa Bulletin, if I want to answer this question very narrowly, no, not a chance at September Visa. Actually, oh wait, sorry, September Visa Bulletin, December 24th, 2014. I give a pretty good chance of that.
I think so.
Yeah,
too.
I'm sorry. I thought you were saying December 2015.
Yes.
Yeah.
All right, I got my I-40. So this is from Knowledge Lust. I got my 45 approval status on 21st, but no card printed yet. Yes, well, congratulations for the green card.
Yeah, that's
Is that normal? Yes.
normal.
It is
It'll take
yes.
sometimes takes a couple days for them to get from approval to card printing.
Also, me and my wife have a Canada PR pending, permanent residency, in final stage for backup, pursuing to it. Just get the card as backup, okay? Okay, so if you go get the green card as a backup, I don't care, although it's a manifestation of abandonment of permanent residency, potentially. But if you come back right away, if you go and do the green card and then come back, let's say within 1 or 2 days, and you need to spread out every evidence that this is really as a backup.
Yeah, I mean, you can't be permanent residents of two places. It would be my narrow answer on that. Is my conservative answer on that one.
Yeah, you're vulnerable. Let's put it that way.
Yeah.
There's a vulnerability a little bit from a logic. I mean, I don't like it. The chances of that ever coming out probably.
Yeah.
On this during the citizenship application, maybe it can come out.
Yeah.
I mean, I don't like it honestly. Yeah. Like again, the chances of this coming out is very slim.
Sam, this raises an interesting question. He says, or he or she, I don't know, says, my I-45 approved, but green card not printed yet. They're on track. They're trying to approve 100,000 green cards in the next quarter. And in the past, when times when they were a lot less busy, they had backlogs with printing green cards. I hope they don't have another one of those.
Well, we're not going to start rumors. We do not know that.
I don't know that, but I mean,
Yes.
it's a massive undertaking to get the cases approved, and also printing them is another challenge.
Plan to be in the United States for the most part, but pursuing the card now, and we are also closed, should not be an issue. Correct? Well, we just answered that question.
Yeah.
I mean, chances of that ever coming out is very slim. The chances of that issue not causing a problem, it exists.
Yeah. Nobody can ever tell you anything 100% for sure.
All right. So coming on 7 o'clock, and I'm disappointed we haven't taken everybody's questions, so we're going to extend for a few more minutes.
Okay.
My priority date is June 23rd, 2015, and currently my permanent is pending with USCIS for a new employer, and it was filed in January 10th, 2022.
Yeah, so basically
I-
new perm filed in January 2020. Oh, I see January. It's got to be January 2022 because any earlier it would
Do
have
I
been
do
approved.
my I-140 in premium case approved? Always do your I-140 premium is the employer supports it. Not all employers support premium, but if you can do it in premium, yes.
I don't know, Sam. Always do I-140 in
Child Status Protection Act.
Child Status Protection Act.
Yeah, and unless you have you got to look into that. If you have a Child Status Protection Act, you have an older child, that needs to be looked at carefully. But yes, did we answer the question?
Yeah, generally speaking, in most cases, premium processing is good. I mean, ultimately, you want to have your I-140 approved when your priority date becomes current so you can get that green card.
Yes. All right. Radvan, if I'm pronouncing it correctly. What is your take on the straight India EB3 candidates with priority date of July 2014? Do you see EB3 priority dates progressing to mid-2000 by September 2023? Please share. Many thanks. So by next year.
So EB3 final action dates presently are 15th of February 2012. This is for the August visa.
I don't
bulletin.
see it moving to
That's
2014.
to mid 2014. No, that's what over about 2.5 years of movement.
No.
So as a reminder for everybody, the way the visa overflow works is it goes into the highest categories, most backlogged first. Meaning all the visa overflow we were talking about, last week is going to go into EB2 categories first.
Correct.
Yeah.
All right, so we're moving here to Raju again. Hi, Raju. He continued. I've heard supplementary form has a correct address, but looks like it was entered incorrectly by USCIS. Oh, it's a USCIS error.
Well, yeah, I mean.
Oh, so shall we bring it up? So he has two locations. Yeah.
Yeah. If you have nothing to do with that other city that they listed, Virginia,
Bring it up. Absolutely.
Yeah.
Service requested and bring it up for correction. Absolutely. All right.
I don't think it matters either way, but they'll probably it's common. I've seen typos like that a lot.
So we got a question from Prabhu Kumar.
Yes.
Prior to date 2014, August 2014, EB2 to EB3 downgrade in November 2020 and filed medicals. Refiled EB2 on May 31st and received all receipts, and both EB2 and EB3 are in the NBC. Do I get medicals ready for EB2? Well, you know what? If I would get medical ready for EB2 because I don't want to deal with an officer who does not want to look at the other file. If he gives you, he calls you and say, I'm ready to approve your case today, send him the medical.
You're talking about somebody who's so profoundly lazy that they cannot take your medicals from the one case to the other.
And missing an opportunity.
Yeah, that would be a terrible
I would get the medical ready. The heck with it. I'm sorry about the expense, but
yeah, if you didn't file medicals with the EB2 case, yeah, I mean that's get your green card during this fiscal year. You've been waiting a decade, presumably.
Get it. All right. I think that's the same.
Yeah, or the same very question is: Can they use medicals from the EB3 to the?
Yes,
they can,
course, but I won't count on it.
Yeah, yeah.
All right, Siva Kumar N. My I-45 was transferred to NBC, then to El Paso, which is NBC. Mm-hmm. They send Noid to submit medicals. That's nasty.
Well, so I guess they're trying to move cases fast, but Noids are nasty, Sam. RFEs are friendly.
Even after submission, is there a new trend to? No, that's just somebody who's an idiot.
I mean, I guess if they
just send them the medical, you're fine.
If they want to put pressure on you to get the case approved, if they want to get your case approved before the end of the fiscal year, I guess that's one way to do it. It's a scary, mean, nasty way to do it.
The only advice is have a lawyer handle the Noid response. Don't do it on your own. Send the medical.
Inappropriate use of a Noid. I mean, obviously, you're going to get your medicals in as soon as you can. That's surprising. Yes. I have not seen that one.
Jagan, is this pending EB3 affecting my 485?
So, I'm going to add a little bit. Is there any sort of prior questions from Jagan? Sometimes they come later.
I don't see anything. I don't see it, but I'm sure there was a prior one.
So if you have a pending EB3 I-140 that's not approved, USCIS says that shouldn't affect you getting an EB2 I-45 approval.
No, it should not affect it.
Yeah, now, if you did a transfer underlying basis, it says it there in the policy that you can go from a pending case to an approved I-140, for example. It's in their recent FAQs as well.
Yes. December 2nd, 2014 priority date. Do you think final action date be current in September 2022 visa bulletin?
So that is a day, literally, poor Vamsi Visu, a day off of current on the visa bulletin. So I think it is possible because they have had people. You got to file your adjustment already. The priority date has been that far. Thereby, I don't know if you got to file yours, but the priority date has been that far. And if they moved it up to January 1st, 2015 on the September visa bulletin, they would likely not be soliciting many new green cards, and that would make them feel good, probably.
Gangadhar filed 485 in November 21 with Company A, and Company A was merged with Company B on January 1st, 2022. Since merger happened less than 180 days after 485, is it going to cause an issue for green card interview? So it's a complex question that requires a little bit more careful analysis because the type of merger is critical. If Company A and Company B merged and Company A was the company that survived the merger, the surviving entity, then there's no impact whatsoever.
Yeah.
If it merged into Company B and Company B is a surviving entity, then you have a successor in interest issue. And
it becomes a question of, is there a valid successor in interest relationship going on there?
Right, yeah, exactly. Is there a valid successor in interest? So 180 days, he's worried about the question of whether or not he can do a portability, I-45 portability.
Yeah.
So if the merger is a sound merger, 180 days is not going to hurt. If the merger is not a sound merger, then the 180 day can save the day. Yeah. It's a complex question that requires a heck of a lot more attention than a simple question.
Well, having less than 180 days after I-45, because basically, if your case gets, I mean, if the company goes out of business, it's rules.
If the merger is not a sound merger, he can do a portability into the new company because 180 days have lapsed.
No, he's less than 180 days after filing I-45.
So this A disappeared, you mean?
Yeah.
Yeah, that's a complicated question.
Yeah, so I mean, it's the sort of thing where if you have an HR department and you're the only immigrant working in your company, I'd say raise your hand and say, "Hey guys, you're taking care of me in this whole endeavor."
So I have consulted with a gentleman who had extremely similar case a few months back, and we've discussed it carefully. So it might require consultation with an attorney. to really, it needs a deep dive into that question.
Sometimes they don't think, people don't think about immigration stuff in these mergers, and unfortunately,
the last thing they think about is immigration stuff, especially if you don't have a lot of immigrants.
The running joke is the immigration lawyer is the last one to know.
Yes.
So raise the question, and you can be your own best advocate on that.
Yes, absolutely. Be a pain in the butt to HR and to their attorney, and ask questions, and consult with an outside counsel. Harrison, hi. Is there any prediction on the visa bulletin, family-based second preference in all chargeability area, priority date 2015? So that's a good question. F2B is.
Here, I will see where it's at right now. I don't know. F2B, that's dates for filing. Excuse me. So F2B, all other areas, is on 22nd of September 2015, and for all other areas, and you're talking about a priority date in October of 2015. So
I honestly do not have a prediction on that.
Well, the bottom line for me is, if F2B, all other areas, is on 22nd of September 15, you're talking about a priority date in October 2015. That's pretty close. If you watch the family side of the visa bulletin, they're moving slow. But you're not looking. I can't say years is likely at this point. However, I have seen it move quite slowly.
Yep. And we're taking the last question here today, 7-11. Can one maintain a priority date received with employment first while on L1B if they move to employment 2 on H1B? And the answer is yes. Yes, you can.
Yeah.
With that, thank you so much. And we try to answer as many questions as we can, but unfortunately, we cannot answer all of them all the time. Come back and see us next week, and we're going to talk about something interesting as well.